Okay, say hi.
Good morning.
Can you hear us?
Good morning. We'll be starting at
Hi.
9:30, just waiting for everyone else to log in.
Hi, this is Catherine and Bill.
Should we mute then until you're ready?
Yeah, that would be great. Thank you.
Happy Wednesday, everyone.
Happy Wednesday. Did Mr. Bradley get in? Oh, there he is again. Great.
He's in. Bill Bolton, what docket are you for? Bill, can you hear me?
Hi, yes, we
Hi,
can
Bill,
hear you.
on the line with my wife, Catherine Bolton. who works for us.
Can you see us?
We can see you. What docket are you here for?
What docket? Is that
The violation, you mean?
is that the hearing number?
Oh,
What-
docket number alpha-103-20, A10320.
Okay, here on. Okay. Gotcha. Put yourself on mute until your docket is called.
We look like we have everybody we're supposed to. Carmella?
Almost. I'm going through. We have the appendix 15. We have the
Is Mr. Dank coming today or is he out?
he's
He's
out.
out.
Okay.
He's out.
Is Mr. Gallagher running the meeting today?
Yes, that's my understanding.
Okay, Mr. Chairman.
Good morning, it's Patty. So I'll remind Mr. Chairman to make the 3 people statement. You only have 3 members then, thank you.
Okay,
Okay, we have representation for 10420. We have representation for 103. I'll see up here. Calling users. If you called in on the phone, state your name, what docket you're here for.
So Carmella, this is Tom Vanover. I've got video, but I'm calling in on the phone for audio.
Okay.
how we looking, Carmella?
Sam.
Can you hear me?
We can hear you.
I'm Pat Hicks, Patricia Hicks, calling in on the phone.
Patricia Hicks, was that your name?
That's correct, Patricia Hicks.
Thank you.
What's your property address?
Say again?
What property are you here for?
I'm here for the property on 75th and Cedar Avenue. Melvin and Luana.
Yeah, that's the first docket.
Okay. All right, everyone mute yourself until your docket is called. Docket is called, you can unmute yourself. Mr. Gallagher, we're good to go.
Okay, all right, we'll start off. The Cleveland Board of Building Standards and Appeals preamble. In compliance with notification requirements of Ohio's open meeting law under COVID-19 emergency declaration, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We'll also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. All meeting activity is being performed by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. We have provided a link to the meeting for those who wish to speak on a particular case by way of our website and email. We have also received emails from those who have provided written comment on a particular matter.
Mr. Chairman, I can confirm that we are currently live streaming on YouTube.
Okay, very good. Ms. Ashton, do you have a comment about the chat
Yes.
feature? Oh, go ahead.
Thank you, Mr. Chairman. As we do each time, the city objects to the use of the chat function as provided under the rules posted on the Ohio Supreme Court website. And if you could make your 3-member statement regarding appeals being heard today. Thank you.
Okay, we only have 3 board members on, so we will have to be unanimous in our decision. And usually we are, so that's what it's going to take. Unless you have an objection to that, you need to state that ahead of time if you don't want your case to be heard. But like I said, could be most of the times we are unanimous. I'm letting you know. Let's go ahead and do the roll call.
Mr. Maskey,
Here.
Mr. Bradley,
Here.
Mr. Gallagher.
Here.
You have a quorum.
Okay, we have a quorum. All right. We'll call the first case is going to be docket A 1820 7515 Cedar Avenue.
Application and fees are in order. Notice of violation is a condemnation of the main structure. Issued December 18th, 2019. Appeal statement was received January 17th, 2020. The appellant requested time to complete abatement of the structure.
And
Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton, Law. If the appellant is present, please state your name for the record.
And Mr. Chairman, Ms. Aston has her hand raised.
Go ahead.
Mr. Chairman, if the appellants could state their names, it looks like they're present, and swear them in, and then I'll make my statement. Thank you.
Okay. Okay, so everybody have they stated their names for the docket? You're gonna have to come off mute.
I believe you're both muted.
My name is Patricia Hicks. I'm here to give testimony for the appellant.
Yeah.
Okay. All right. I'm gonna. Is there someone else on this case, or is that it?
Yes, Lawana and Melvin, Lawana Graves and Melvin Logan Jr.
Okay. Is there anyone else? Okay. If you would raise your right hand, solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Yes.
Thank you. This is Patricia McGinty, Aston City, Cleveland Law Department. I did not hear what Ms. Hicks stated she was here for. I thought she said she was here for the appellants, but Mr. Chairman, on behalf of the city, I did notify Ms. Davis yesterday that the city would be requesting that this board find and state in its resolution this property at 7515 Cedar Avenue. The public records indicate that it was transferred from Mr. Logan and Ms. Lawana Graves on January 9th, 2020, to the new owner of record, which is Cedar Logan Estates LLC. It appears that Mr. Logan filed this appeal on January 17th, 2020. It appears that he is, we're going to ask who he's representing, but it looks like the new owner filed this appeal, Cedar Logan Estates LLC. And we would ask that you find that they are filing this appeal on the behalf of the new owner, Cedar Logan Estates LLC. Otherwise, they cannot proceed if they're not going forward because they no longer own it in their personal capacity. And if they are proceeding on behalf of the new owner, we ask that you affirmatively find that and so state in your resolution. Thank you.
Okay, well, let's hear from who's going to talk about this from the appellant side.
Okay, well, with the transfer, we are still owners, but again, it was in the process of us seeking funding that we put it in a business name. So I guess it was a technical error in between of us receiving the actual notice. But everything that the inspector wanted us to do as far as the property, board it up and secure it and keep it clean until we actually find move to the first phase. We have done that. And now we're just, I did consult with real estate attorney Virgil Brown, and we are asking for an extension so we can proceed with assembling a team.
So is that sounding to me like as if it hasn't transferred?
Well, yes, it transferred. It was transferred, I thought it was in December. It was actually transferred in December. And we were was in the midst of finding funding, looking for contractors and so forth. So that was something off our list. And when we went to go file the appeal, it came in our name. So my husband and my name. And so we just filed the appeal based on the documents that we received.
Okay, well, maybe we can get some clarity from Mr. Vanover.
So just to be clear, the violation notice is issued in your name personally and you filed the appeal personally, but it is since transferred to your corporate entity? Is that accurate,
Yes.
Mr. Chairman, to the appellant? Okay. So as private persons, you were ordered to abate the nuisance of condemnation. This is a large building, a very large building. And I guess my next question is, what is the plan going forward? We don't object to more time, providing one, it's funded, and two, that time is reasonable.
Okay. Mm-hmm.
Go ahead.
Okay, yes, we are in the process of getting a team, and when I consulted with Virgil Brown, that's our attorney. He wasn't able to make this meeting, but he is on board as far as the following meeting. So he requested that we ask for 4 months to get the team together and paperwork wise and funding. Hold up, let me get the paper. I don't want to read off. What? Sorry, excuse me. So basically the 4 months time frame would consist of us with going forward with the future architect. Our business plan will be completed this month, late this month, early next month in April. So, financing and general contractor. So we had were looking prior to this, we had our architect, we had a contractor and so forth. We sent over the contract to Ms. Davis that we had previously. Now we're starting over. So since we just consulted with Berger Brown, he's stating we're going to at least need 4 months to present everything that you need for the board moving forward.
Mr. Vanover?
So, Mr. Chairman, to the appellant, so Mr. Brown is your attorney?
Yes, he's our real estate attorney.
Mr. Chairman, to the appellant, who is your architect?
Well, our architect that we had previously, it was, one moment, I have the contract right here. Just one moment, please. His name was Ibram. Last name is Hankey, Hakki. He's going to continue to be a mentor on the project, but he wasn't, for some unforeseen reason, he wasn't able to, they can still see this. Okay, he wasn't able to continue his contract with us, but we have our business consulting gave us a new architect to continue to work, and that's why we are needing a time frame, because we're in the middle of forming the team.
So, Mr. Chairman of the appellant, when did you purchase this property?
2016, October.
We gained.
2016, October.
Okay. Did you hear? Oh, hold on.
I did not. I apologize.
In October of 2016?
2016.
Yeah.
And okay, so we're so we're four and a quarter years into this. So this is a substantial project, and you've got Mr. Chairman, the appellate. My concern is that you've got lawyers and you've got business consultants and mentors, but I don't object to more time, but there's a need for architects and contractors, and I still haven't heard the funding model and if the project is funded.
Well, we're again in the middle of seeking a contract, and with the Port of Cleveland, that's where we're going forward with one of the funding. I don't have all the information. That's why I wanted to actually get timing on all the people that would be on board, or the finance committee that would be on board as far as funding the project. But that's our last meeting, was submitting the application for Port of Cleveland.
So, Mr. Chairman, to the appellate, what is the timeline on that decision?
Well, since we're starting with a new architect, and we just, what you want to say? Oh, I would ask at least 4 months for us to come back with the board with our paperwork and our designs from the architect and so forth for phase 1.
So, Mr. Chairman of the appellate, what is the timeline on when the Port Authority is going to make their decision?
Could you repeat that?
So, so you said that the Port Authority, that you made application with the Port Authority for funding, the Port of Cleveland, and you're in the middle of that application process. When will they decide if you get the money or if you do not get the money?
Well, the answer to that is we're completing the application for the port. and they gave us a list of things to do. So the list of things we are completing, and that's one of the reasons why the building had to be transferred into our business name. So the list that they gave us is like almost like a one shot at it. So we have everything lined up to get the meeting. So when you have the meeting and the checkoff list and the meeting is completed, that's when they say yay or nay. The next meeting will be like, we're going to give you this or you deny this. So the goal is to come with everything completed, and that's where we at with it now.
So, Mr. Chairman of the appellate, when is that meeting?
Well, we just consulting a new architect, so we want to make sure we have, the architect is advising us, it's going to take him at least 4 months before the drawings is in place. So he said it was a process. So I'm not with the coding and submitting it to the city and so forth to make sure the city approves what we have plans for. So if we can come back in 4 months or even if we...
Mr. Chairman, to the appellant.
Go ahead, Mr. Maskey.
A couple questions. Just to clarify, did you say you've owned this building since 2016?
Yeah.
Okay, so that's 5 years now and nothing's been done. That's the first statement. Secondly, who is your current architect?
It was, our previous architect was Ebram.
I don't care about the previous architect. Who's the current architect?
We are in seeking of the one that we, our business consultant.
You don't have one. Okay, third question is, do you...
One moment. Just one moment. I don't want to say the wrong name. Just one moment, please.
Mr. Chairman, Ms. Williams has her hand raised. I'm not sure if she has something to say pertinent to this case or a different question. I just wanted to bring it to your attention.
Okay.
I'm not done yet.
Okay, just one moment.
My concern is if you don't even know who the lead person, who's the most important person at this time, then we're going down the wrong path. My last question is, have you ever done a project before or a project of this size?
Okay, let me answer your question from beginning to end. The first question you asked is, we had the building since 2016, and we have done things to the building as far as, what? He said we haven't did anything, so that's not true. Okay, so we made sure that we did clean out of the building. So the building had rubbish. We boarded up the building and we maintained the outside cleanliness of it. So that's what we did on our end. And then we see contractors, architects, and business consultants. Your second question was the architect. We had a previous architect that just advised us that he can no longer assist because of his personal reasons. I gave you that name, and I gave you a contract that we had with the architect. The moving forward, Timothy Amos, our business consultant, has completed projects in this realm of the YMCA in Akron, as well as other big projects of this magnitude. We had a business consultant previously that didn't have this type of knowledge. So Timothy will be completing our business plan, and his consultant that we're going to use, architect, is called T as in Tom, C as in Charlie Architects. www.tcararchitects.com.
Okay, thank you. Mr. Chairman, after hearing this, I don't think that the appellant needs to stop working on this, but I don't think we should give them more time. I think there are a lot of things that need to be resolved, and I find that I don't think in 4 months they're going to be resolved when they come back to us. So I think we should remand this back to the city. They can work with the building department. Mr. Vanover and his team can keep close contact and review of the project, but I don't think giving any more time is going to resolve anything.
Okay, let me check and see who this Miss Williams is.
And we also have a Wanda Thomas that raised her hand.
Okay, yes.
Okay, Mr. Chairman, my name's Regina Williams, and I'm a resident of the community. I live on East 76th Street off Cedar, and I'm a social historian. I met Mr. Logan last summer when he was working at the building, cleaning the grounds and mowing the lawn. But I've been in touch with the Logans and also with Kathleen Crowther at the Cleveland Restoration Society and Joy Johnson at Burton Bell Carr, and also with Councilwoman Phyllis Cleveland. I think this is a wonderful historical structure. I'd like very much to see the Logan Estate LLC pull this whole thing together, restore the building to its original glory, to see them realize their vision for having sort of a mixed-use complex with small businesses, if we call it a small business incubator, and maybe affordable housing for the residents of this community. But I also understand, as Kathleen Crowther said in her first email to me, and that was on Blizzard Day, I believe that was the third week in February, that it's going to take a lot of capital. But she suggested that there are some things that can happen that would make possible a public-private partnership so that they could retain ownership of the property and work in tandem with the city of Cleveland, Burton Bell Carr, again, to restore the building to its original glory. And I also know from speaking with my neighbors in the community that there are other property owners who want to see the building restored. So I'm hoping that we'll be able to do that. And I am willing. You know, they have expressed, Luana and Melvin, a willingness to work with a historian, to do the research, to be part of the team. I am not an architect, but I know that in the messages that I exchanged with Kathleen Crowther and the Cleveland Restoration Society, she is in touch with architects and other individuals in the community who would be willing to work with the family on this project. So that's Councilwoman Cleveland told me that she would not be able to attend this hearing because she had a previous engagement, but she encouraged me to speak my truth about the value of working with this young family, these young business owners, and other people of goodwill in the city of Cleveland. So I'd like very much to do that. I'm not aware of the exact timeline that would be required, but I know from my most recent email from Joy Johnson at Burton Bell Carr that she is willing to work with me to support Melvin and Luana and Logan Estate.
Thank you,
So I
Ms.
just wanted to say that.
Okay, very good. Thank you. Is there someone else with their hand up, Maurice?
Yeah, Wanda Thomas.
Wanda, okay, go ahead.
And Don Pettit after that.
Okay.
Good morning, Mr. Chairman. My name is Wanda Thomas, and I am Luana's mother, and Melvin is my son-in-law. So I've been working with them as far as the building completion. When it was first turned over to them, they actually cleared out the building, made sure that the structure was at least safe from the community. They continue even now to make sure that that part is maintained. They do have the support of the community. I believe one of the questions that was asked, I was on my phone, but I couldn't raise my hand, but I could hear, is the architect, which is Ibrahim Haki. He is still part of the team. He's currently working on the code analysis just to ensure that what is needed to make the building safe. I know it was mentioned that we're working with Timothy, who's from Akron. He as well have completed a project of this magnitude and rehab the MCA in Akron, Ohio. We do have links of his work in addition to that. So he actually started just before they received the letter of the hearing. So we should have the remainder of that report by next week. He also is helping us with the application with the Port of Cleveland. And again, it was mentioned that they did request a lot of items, and Melvin and Lawana have worked tirelessly to get those items. Of course, when COVID happened, the team that was structured, actually, we had to go our separate ways because we want to see the building restored to its glory and even better than what it's been before. So we pulled together a very solid team as well, and we're asking for whatever time, whatever mentorship that we can have from the city of Cleveland. We would like to return that favor by even giving jobs to those that are in the community by working with Ohio Means Jobs and with, again, the city of Cleveland.
Okay, thank you for your comments. Maurice, do we have another one with their hand up?
Yes, Mr. Pettit.
Mr. Pettit, go ahead.
Thank you, Mr. Chairman. I'm Don Pettit. I'm Secretary of the Cleveland Landmarks Commission. We were just made aware of this case yesterday afternoon. So we're getting involved very late in the game. We know very little about this building, except for the fact that historically it was a YWCA. I'm not fully up to speed on the condition or the viability or the integrity of this building, but we were approached by Ms. Williams yesterday and Kathleen Crowther at the Cleveland Restoration Society. Given all that, I would just say that we support a reasonable request for more time, just so we can do some more investigation on the history and significance of the building. Thank you.
Okay, thank you, Mr. Pettit. I want to go back just a minute to Mr. Vanover and also on what we're hearing from our board member too, that there's a lot of moving parts to this, and a lot of things seem to have to come together, and putting a time on it seems kind of difficult. So I'm not sure, Mr. Vanover, you think this is something that maybe should be remanded back to the city so that you can review this as it's going on? Oops, I got a notice that Mr. Vanover has left the meeting. So let's see, Mr. Maskey, who's back?
Mr. Chairman,
He's here.
Tom Vanover's here.
Okay. Did you catch what I said, Mr. Vanover?
I did.
Okay.
So, if we could, if we could scroll through the next group of photos.
Go ahead, Maurice.
On the PowerPoint.
Okay.
So you can see the condition of the building is not good. There is, and it appears that the bed downstairs boarded up, but the upstairs windows are still, at least at the time of these photos, is wide open. I don't disagree with anything that anybody has said. This is a large building, and I will begin by, for the record, to say that like every building, but especially one this size, the City of Cleveland Department of Building and Housing has no desire to tear this building down. If it has historic significance, especially, but we don't want to spend public funds to abate a nuisance that should have been, that's for a privately held building. The citizens of the city of Cleveland should not have to pay for that. My concern is that this is 4.5 years, 5.5 years, depending on the timeline, that this building is, that they've owned the building and nothing has happened. This was well before COVID. So I'm concerned that the viability of this building depends on funding that is unclear. It depends on, whether it be entitlements or philanthropic, capital to be influxed into the building. Right now, it's kind of an idea, but not a plan. I don't object to more time, but that's more time to follow a plan. And at this point, we don't even know. I'm assuming that the appellant was getting to the point where they needed architectural drawings to take to the port. But I'm not clear that was actually the statement that was made. So
I think it was to you, the city, Mr. Vanover. I think it's what the statement was made, that they wanted to bring the drawings in and to have all that done within this 4-month period of time that they were requesting. In other words, to have a full plan review with you with drawings at that time. So that would be the question.
But Mr. Chairman, I guess my question is, before that, is how is all of the architectural design and all the pre-planning, how is that being funded? And what is the funding model? Is there any private capital from the owners that is going to be influxed into the building? What are those? If it's not funded, then it's not going to, then it's a no-go. We've seen too many times a plan in hopes of getting funding through some entitlement program or philanthropic source, and then it falls through, and all it does is, I don't know when the last time this building was occupied, but it's currently condemned.
Mr. Chairman, we have Wanda Thomas with her hand raised again.
Oh, go ahead, Ms. Thomas.
Mr. Chairman, I want to say that the actual plan started just before COVID. Initially, it was just getting the building cleared out, which was a huge responsibility, and it did take several months to be able to do that. All the funding has came from Luana and Logan with the support, but now that we have a team around us that has stayed the course, have done projects similar to these, this is the reason that we're asking for that. I think it's going to be a win-win, not only for the community, but also for the city to see it up and running, to be able to create jobs within the community and for the city as well. So I do understand that they've had it for a long time, but this shows part of their dedication as well in order to get the building up and running. It could be sold. However, they've done the course of the historic. I'm glad we do have someone on the left regarding that we're going to look into some of the things that we can keep with the building, and then with the new codes, because of the new buildings that are going on around the community, we want to make sure that code analysis stays the course as well, and that's where the architect or architects will work with the city of Cleveland in order to make sure that the building is safe, is secure, and is vibrant in the community.
Thank you.
Mr. Chairman, Mr. Maschke has his hand raised.
Very good. Mr. Maschke.
Yes, Mr. Chairman, I agree. I think this building needs to be saved. I think the appropriate time is necessary to do it right. However, it's been sitting there for quite some time, and remanding this back to the city does not preclude the appellant from continuing to work in conjunction with the city and the Landmarks Commission and Mr. Pettit to make sure that the building is restored and renovated to the appropriateness. So I would like to make a motion that we remand this, that the notification was issued correctly and that we remand this back to the city for observation.
Very good. Is there a second?
Second motion.
Okay, second by Mr. Bradley. Motion by Mr. Maschke, second by Mr. Bradley. Call the roll, please.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes. Okay, the motion is passed. So the parties will be notified in writing. Okay,
Thank you, Mr. Chairman.
yes. I can't hear who's ever talking.
If you're not speaking and you're on the telephone, please mute your microphones. Thank you. It looks like Wanda Thomas has her hand raised.
Go ahead, Ms. Thomas.
I want to thank all of you for giving us the opportunity to move forward with the building. Look forward to working with you, and once COVID is over, maybe seeing you at the City of Cleveland as well.
Very good, thank you. Okay, we're going to move on to the next docket, docket A-10320, 812 Huron Road.
Application and fees are in order. Notice of violation. Wait a minute. Notice of violation is interior and exterior maintenance. Well, I'm sorry, interior maintenance. Issued October 28, 2020. Appeal statement received November 24th, 2020, requesting for time to abate the violation. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton Law. With the appellants, please state your name for the record.
My name is William Bolton, and I'm with my wife, who's also active in the management, Catherine Bolton.
Is there anyone else giving testimony?
No.
We do have a contractor who we can patch in.
Oh, hold on, Mr. Chairman, you need to swear them in. Thank you.
We will swear them in. I'm just finding out the names of who's going to be giving testimony.
Mr. Chairman, we tend to call anybody, but we do have a contractor who we can call should your questions merit it.
Okay. All right. Solemnly swear to tell the truth, the whole truth, to help you God?
We do.
We do.
Okay. Okay, go ahead and tell us what your plans are.
All right. Well, this incident occurred in the Caxton building, which is located at 812 Huron Road. It's a roughly 220,000 square foot building, which is occupied with offices from the 2nd to 8th floor. And on the 1st floor, it has retail space. Last fall, quite surprisingly, a refrigerator burst into flames in a small office on the 2nd floor, and the sprinkler system immediately put it out. And the damage which we're talking about and this violation were caused by the water infiltration in the restaurant, which is located below that suite. We immediately, as landlords, had Belfour Construction, which is an emergency remediation company to prevent, for example, mold. They came and it took appropriate steps so that there would be no mold, and removed the loose debris from the ceiling. The picture which is showing, those pictures you're showing of the ceiling do show where the paint is removed, any loose plaster was removed. And the restaurant has been closed since then. So our understanding is that the issues with the space is in the reopening. When we would like to have it reopened, they've been closed to the public since October, and COVID-19 has caused the restaurant many issues, including no business and the inability to have enough people in there to succeed. We're in more or less a holding pattern, waiting to hear whether they want to reopen or not, because if they reopen, we want to know, do they want the ceiling the way it is? And do they want to have the existing floor refinished, or do they feel it has to be replaced? They also had some trouble with their kitchen in 2019, and it's our understanding that they are working with their insurance company to get that repaired. So they have not let us know what they want to do. And we are certainly going to repair those. This is a functioning and economically successful building in downtown Cleveland, but it just doesn't make sense, and particularly with the difficulties of COVID, it doesn't make sense to put money in, and actually quite a significant amount of money, if it's not going to go towards reopening a business in downtown. So if the tenant leaves, we're going to fix it one way, and if they stay, we'll fix it a different way. Thank you.
Mr. Vanover.
So, Mr. Chairman, to the appellant, if you could restate, where was the refrigerator? Was it on the first floor?
No, sir, it was on the second floor, and Inspector Santora has been to the building, and I think he was the one who filed the violations. And I believe he also has seen them.
Yeah, all right. And then, so this is, Mr. Chairman, to the appellant, this is Wilbert's?
Right.
Yes, it is.
Okay, and they've been closed since last year. So, again, Mr. Chairman, you know, it is an open violation that needs to be addressed. Is there any timeline, Mr. Chairman, to the appellate on when Wilbert's will make a decision on what they want to do?
We haven't set one, but I think opening day is going to be important to every restaurant downtown, or certainly in our neighborhoods. So I would expect that we would be able to make a decision as to what kind of repair to make by, I'm floating a date, by July 1st.
Well, I think the issue really is that I don't think Wilbert's has decided what they want to do. We have not heard from them. They closed in October because of COVID, and first of this and then COVID. You know, the CDC required that all restaurants and bars be closed. So we're waiting to hear back from him. He's on a month-to-month lease. He does not have a long-term lease with the Caxton Building and Property Operations. So we're, you know, we understand that we want to fix the violations, that we must fix the violations, but the issue is there's two different ways of doing that. In order to fix the ceiling, we have to take down the lights and do, you know, and replace all the hanging clouds. And it depends whether he's going to go back into that space or whether another tenant will come in and want us to do different work.
So,
Mr. Chairman, I just want to point out that Ms. Aston has her hand raised.
Okay, well, let's hear from Ms. Aston.
Thank you. I don't know if Mr. Vanover was going to address this, but if you just stated, Mr. Chairman, to the appellant, you just stated that they're on a month-to-month lease. So the requirement to abate or correct these violations falls upon the property owner or / management company. Is that correct?
Some does and some doesn't because of the insurance claim on their kitchen.
Right. See, they had a fire in their kitchen in 2019, so they have no functioning kitchen. And they're in litigation.
So the fire was in 2019, not in 2020. The violation was just issued in October of 2020, correct?
No, I'm sorry. There's two different incidents we're discussing, ma'am. So Wilbert's had a fire in 2019 and their kitchen burned. So they have no functioning kitchen. Our fire was in September. A small mini fridge burst spontaneously into flames on the second floor. The sprinkler head went off immediately, and then the water went down through the floorboards into Wilbert's.
The impetus for this violation notice before the board was the September of 2020 fire?
Yes.
Right, exactly.
And is that related to Wilbert's?
Yes.
Okay, so, and Wilbert's had a fire in 2019?
Right.
Yes.
Okay, but they had no violation. City did not issue a violation notice in 2019. We issued this in 2020 that you're here for the board. The insurance claim, is it related to this September of 2020 fire for which the violation notice was issued?
Well, there's two separate issues going on here.
The board has the violation notice in front of it for 2020. So I'm asking specifically about the fire that's in relation to this violation notice. Is there a claim for the fire insurance?
Yes.
And what is the status of that fire insurance claim?
It's an open claim.
There's been no determination by the insurance company as to the valuation?
They have come and looked at it, and they've come back to us and say, you know, can you please give us the scope of work?
And did you do that?
Well, the scope of work is open depending on whether Wilbert's is going to reopen or not.
So
Mr. Chairman-
the answer is no, you did not give the insurance company a scope of work.
Well, it's a little more complicated.
They've come through and seen it. They've given us an estimate if we were to restore it to its original, if Wilbert's was to reopen.
And what was that estimate?
I don't have that with me. It's
okay.
I mean, it's you know, it's expensive. Yeah.
No, I don't
we have
doubt.
to redo the ceiling.
Absolutely don't doubt it's going to cost quite a bit. But you're requesting that things just kind of wait until a third party makes a decision with a violation notice open. I don't know what Mr. Vanover as the chief building official is going to state, but normally that's not really a plan while we sit here and wait with a violation open. I expect that if that testimony doesn't change, Mr. Chairman, the city would ask that you uphold the violation notice and remand to the building department for further proceedings, because you're just asking that we're waiting, and if there was an incident in 2019 and now there's another incident in 2020, and we're waiting for a third party that's on a month-to-month lease that may or may not do something, that's a little unreasonable. Thank you.
Yeah, I think the board is inclined to think the same way, but let's hear from Mr. Vanover.
So, Mr. Chairman, to the appellate, what is your ask?
We would like additional time. Part of this time that has occurred, that has passed so far, was due to trying to deal with the insurance company to obtain an estimate of what they were willing to pay. I must say they've been very, very nice to deal with, although there's still a difference in what our contractors say it will take and what the insurance company has offered. So between the COVID, it's affected us and it's affected the restaurant. That has caused most of the delay to date. As I'm sure you've heard from many, many people downtown who have violations. And we're asking for a bit of time more to deal with the underlying business issues. And anyway, even if we went out, we had a contractor ready to go and they've now become too busy.
So, Mr. Chairman, to the appellate, yes. I'm going to ask again. I'm aware that you are asking for more time. All right. What is the ask?
Well,
30 days?
We understand that we'll have to get permits. And of course, we understand that we have to correct the violations. So how long is how long is it now taking to get a permit? Will the contractor need to submit drawings to sand the floor and repair the ceiling?
Well, if you, based on your testimony that they have to remove the clouds and the lighting to patch it and place it, depending on the scope of work, yes, they will need plans. And they will need, they'll need drawings and they'll need applications for permits, correct?
Okay, will they need the electrical permit too then?
If they're doing electrical work, they will. If they're doing plumbing work, they will. I don't know what the scope is. So,
yeah, no, there's no plumbing work. It's the ceiling, repairing the ceiling, repairing the floor. But in order to repair the ceiling, they have to take down the light fixtures. So they will. And are there any fire violations? We're not aware of any fire violations. What else would you like from us? I guess that's what we're asking.
Well, what I would like from you is to make application, pull the permits, and fix the violation that were issued. The violation that was issued was for the water damage to the first floor.
Right.
And the expectation is that you provide, either through a design professional or through your insurance or your contractor, however that works, that you provide a scope of work.
Yep.
So
okay.
We're 6 months in already. And from the time of the fire event. So I still don't, I mean, what is your expectation other than to this holding pattern?
Well, we are a viable business. The city is requiring us to repair this, but even if you weren't, our lender would require us to repair it. We are going to repair this. What we would like is an additional 3-month extension to July 1st. That will give us the time to work out the business issues and to engage the necessary professionals to get contracts to submit for a permit.
Right. Are we
Okay.
able to get a permit in 3 months, you think?
I want 3 months.
Mr. Chairman, Mr. Maschke has his hand raised.
Go ahead, Mr. Maskey.
I'd like to hear Mr. Vanover's response first before I comment.
Okay.
So yes, if you make applications, submit your plans, and depending on, and everything in the plans is complete, then yes, you will be able, this is an interior alteration, so there's no zoning or landmarks implications. So yes, you can. We don't object to what you said, the July 1st date to abate the nuisance.
Okay.
Oh, well, I was actually asking, I'm sorry to interrupt, Mr. Chairman. I was actually requesting that we have until July 1st to begin the process, which probably means that design and permitting would take another perhaps 2 months.
Mr. Chairman, we object to violation being open for 9 months before they start the process.
Yeah, Mr. Chairman, now I'll comment. I concur with the city and Mr. Vanover. I too would like to see this building get cleaned up and resolved as soon as possible. And it doesn't preclude, like the last case, this doesn't preclude the building owner to do that, even if we do remand it. So I would like to make a motion that everything was issued correctly and remand this back to the city for further observation.
Okay, so we have a motion to remand this back to the city, which doesn't hurt the owner from correcting the violations at all. Is there a second?
Second motion.
Okay, so it's been moved by Mr. Maskey, second by Mr. Bradley. Is there any questions so far on the motion? Okay, call the roll, please.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes. Okay, so it's been moved, and you will be notified of that decision. Okay.
Thank you.
On. You're welcome.
Thank you for
Thank you for your
consideration.
consideration. Well, I'm sorry, I don't mean to be not understanding, but what is the decision, so I understand what's happening?
Well, you're going to work with the city to get this resolved, okay? And you move forward as fast as you can with it, and that's the plan. You got to get moving on it. As long as you're making progress and moving on it, no problem.
Okay, thank you so much. I just wanted to understand what the decision was.
Sure.
All right. Work with Carmela?
No, it's been remanded back to the Department of Building and Housing.
Oh, okay. Thank you, Carmela. Thank you for explaining.
Anytime. Okay.
Okay, sounds good. Thank you very much. I appreciate your time, everybody.
Hey, thank you. Okay, next docket, A10420 4057 East 131st Street.
Application and fees are in order. Notice of violation is condemnation of the main structure. Issued October 19, 2020. Appeal statement received November 9, 2020, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing. Patricia Ashton, Law. With the appellant, please state your name for the record.
This is Attorney Kristen Carson, here for Appellant Clifton Hopkins. And also the appellant is present with me as well.
And we have Miss Aston with her hand raised.
Miss Aston, go ahead.
And Mr. Chairman, preliminarily, before you swear everybody in, the city of Cleveland states that in their appeal statement, it appears, and I notified Ms. Davis of this yesterday, Upon review, the appeal statement appears to do an alternative, seeking time, and as well as they've objected, saying the notices are vague, et cetera, according to their appeal statement. Then Mr. Vanover is prepared on behalf of the city to meet its administrative burden to demonstrate the violation notices for the main structure and garage were issued correctly. Upon conclusion, we are going to ask that you uphold the violations as issued correctly. And I defer to Mr. Vanover after you swear everybody in. Thank you.
Okay, everyone that's going to be giving testimony in this, please raise your right hand. Solemnly swear to tell the truth, the whole truth, so help you God.
I do.
I do.
Okay, does the city want to address that issue first, or do you want the appellants to go first here?
You can let the appellant speak first.
Okay,
Mr. Chairman.
go ahead. Mr. Carson?
Yes, thank you. May it please the panel. This violation notice was issued on October 19th, 2020. We are requesting a 1-year extension of time. My client intends to repair the property to code. He has been active in arranging the to repair the property to comply with the order. He has hired an architect. I believe it's Charles Hall from City Architecture to prepare the plans that are being displayed on the screen right now. I believe that they've been submitted to the city. He's hired a general contractor to prepare an invoice, which was just received on the 26th of February of this year. And I did send that this morning. I apologize for the lateness of that. I don't know if it made it into the stack of evidence. But the total amount was $81,996 to completely renovate the property to code. And the appellant has the funds to repair these in a bank account. I have personally seen this. I sent that as well this morning. Of course, I understand it's untimely, but I did personally see it. As well as there is a pending permit for the demolition of the garage, which was applied for originally on December 16th, denied, and then on January 20th, the second permit for the demolition of the garage was applied for, and it still remains pending. We are not aware of the reasons why it has not been approved yet, but that was the first stage of the appellant's repair process. So we're requesting a 1-year extension of time, a shorter amount of time to apply for the permit if it please the panel. But that is all I had.
Okay, Mr. Vanover?
So, Mr. Chairman, I'd like to begin. The appellant, counsel for the appellant has not withdrawn their statement of objection to the violation notice with their request for time. So I would like to pose testimony showing the pictures that we've provided that in fact show that the violations do exist. And the notice of violation on its face is specific to the items within the building that are deteriorated and that are not in compliance with the code. I think it is my position that the violation notice itself is specific and detailed, and that the supporting photographs prove and support the violation notice as properly issued. And so we would ask that the board find that the violations do exist and that the violation notice was properly issued. That
we'll give
being
Mr.
said,
Okay, I thought we'd give Mr. Carson a chance to respond to that because it sounded like they're agreeing and moving forward.
Yes, we'll withdraw the objection to the violation notice.
Okay, very good. Mr. Vanover.
So that being said, Mr. Chairman, it's encouraging that this is a handsome building that I think would be, like all buildings, are worth saving if it makes sense. So this is a handsome building, and it appears that they're making the right progress. I was researching to see if there had been an application submitted for the renovation of the building. I'm not able to find that. We wouldn't object to a limited period of time to submit plans. And then we object to a year on any structure. The reality is, and I don't know when this was actually purchased by the current owner, the city's position, I'll state for the record, is that when you own property, there's an expectation that it is maintained prior to the city telling you to maintain it. And if it was purchased for the purpose of renovation, the condition of the property, that influences the cost of purchase, obviously. So there's a response. That being said, there's a responsibility of the owner to have done this already. But it appears that they're on their way. We would not object to 180 days to abate the violation notice, with 60 days to make application and receive their permits. And as always, once the permits are applied for, received, and work is progressing, the Ohio Building Code takes over for the timeline, and providing work continues to progress at that point, the permits will stay open and we'll continue to work with them.
Okay, Mr. Carson, you heard what the city is asking, that you get the application and everything in within 60 days and complete within 180 days.
May I have one moment to confer with my client here? Just twice. The appellant was concerned that the building permitting process was quite slow with regard to the outstanding permit garage demolition. We would ask for at least one more month on the permitting process, as well as an 8-month deadline for the completion.
So we're looking at maybe a June 1st timing to get the, let me take a look here, to maybe June 30th to get the info in, and maybe a November 1st to complete. Any board members have any questions about that? Mr. Maskey?
We would be fine with that. Sure.
You're good with it? All right.
Mr.
Go
Chairman,
ahead,
we object to November 1st. I will concede if an additional 30 days for the permitting process, although I don't believe it's necessary. But 8 months to complete the renovation of a project that should have never been allowed to get into this condition to begin with. We object, as we always do. Our standard is 180 days. As I said, the Ohio Building Code will allow for them to continue work. Oftentimes, the delay in the permitting process is time that is delayed by the applicant, because there's an adjudication response and the time it takes to respond to that. I don't know about the specific demolition permit, why it was denied the first time, what the responses were, so I won't speak to that. But we object to November. When I think September is sufficient.
Okay, and you're right, because it can proceed as long as they're making progress. So yeah, it's probably better to have the tighter control with the ability to carry on as long as you're making progress, so it's not sitting. So we'll go with we'll make get a motion for find that the violations and the condemnation was correct. And June 30th to get all your permits and information in, and September 1st to complete the violations. Motion so in order.
So moved.
Moved by Mr. Maskey.
Second.
Second by Mr. Bradley.
Discussion?
Go ahead.
If you could put a year on that, Mr. Chairman?
Oh, yes, 2021.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes. Okay, so the motion is passed. And you will be notified.
Thank you, Mr. Chairman.
Okay. The next docket is A9820 12720 Wanda Avenue.
Application and fees are in order. Notice of violation is rental registration and exterior maintenance. Issued September 18, 2020. Appeal segment received October 9, 2020. Requesting for time to abate the violation. Present for the hearing, Tom Vanover, Building and Housing. Patricia Ashton. If the appellant is present, please state your name for the record.
Mr. Chairman, Patricia McGinty Aston for the City of Cleveland Law Department. I'm not hearing anybody chime in. I will do my, if you wouldn't mind, I will do my request to Ms. Davis, and if they chime in, that's fine. Mr. Chairman, Mr. Chairman, to Ms. Davis, the appellant not having to apparently appeared today for docket A9820. Was the notice of today's public WebEx hearing returned to the board's file for any reason?
No.
And Mr. Chairman, to Ms. Davis, did you receive any communication, notification, email, phone call, voicemail from this appellant regarding this matter?
No.
So, Mr. Chairman, based upon Ms. Davis's statements and testimony to this board, the board does have the authority to proceed, having given proper due notice to the appellant to appear before this board and give testimony. And I would defer to Mr. Vanover. Thank you.
Mr. Chairman, I will say that there is a Patrick listed in the participants list and they are muted. I'm not sure if that is the Patrick Garrett for this house.
Yes, it is. Yes, it is. Sorry. Yes, it is.
There you go. That's what I was waiting for.
Okay, technical difficulties. That's what I thought. All right, go ahead.
Okay, so we know we have Patrick Garrett on here for that case. So are you the only one giving testimony?
Yes, I am. Sorry, I'm out working. I have a lawn care business and I couldn't get on. Sorry.
Okay, I'm going to swear you in. So all those giving testimony solemnly swear to tell the truth, the whole truth, so help you God?
Yes, sir.
I do.
Okay. All right, so let's go ahead and hear what your plans are.
Well, my plan is to fix the roof. This is what the citation is about, correct?
I believe so. We'll hear from Mr. Vanover, but that's what it appears for what I can see in the photos for the violation.
12720 Wanda Avenue.
Yeah, so Mr. Chairman, the violation includes the roof, it includes the stair structure, and it also includes some of the mist and loose siding. But it's also failure to register the property as a rental property.
Okay, there you go. You have your violations.
Okay, my mom lived in that house, and you know, due to COVID, I had lost some work, so I had taxes due on the property, and I put the property in my business name to save my property. But the house is going back in my name. The house is mine. I didn't know I had to register the house because my mom was living in it, but I can register the house. I do whatever you guys want me to do. I just went back to work maybe about 2-3 days ago. I'm just asking for time to get the roof done because it's gonna cost me anywhere from $7,000 to $10,000 to do it. The roof does not leak, but it is an old roof. I'm not disagreeing with that. It is an old roof. I'm just asking for time, so I could get the monies together because I'm just now really getting back to work.
So,
Okay,
Mr. Chairman,
go ahead. Go ahead,
Mr.
Mr.
Chairman, to the
Vanderbilt.
appellant, every structure in the city of Cleveland that is not owner occupied is required to be registered as a rental property. There is a process by which you can file an affidavit saying that you are not collecting rent and a family member lives in the home, and that will waive the fees for the rental registration. However, you are required, if it is not your primary residence and as a corporately owned property, it can't be your private residence. So you are required, if it's not your primary residence, to register it. And that goes for any other rental property or any other property you may own in the city. Mr. Chairman, to the appellate, give me a date on when you will have the roof completed.
If it's just now March, right? If you guys could give me 3 to 4 months to come up with the monies, I will have it because I do lawn care, and this is the heart of the city. We're about.
Okay, Mr. Vanover.
Mr. Chairman, we don't object to April 5th to register the property as a rental and June 15th to abate the violations. Again, you'll need a permit, Mr. Chairman, to the appellate. You'll need a permit for the roof, but that also includes all the violations. So it's fixing the stairs as well as fixing the siding. Just as a point of clarification, understand that because this isn't a business name, you will have to have a contractor pull your permits. So we don't object to those timelines.
Okay, sorry for cutting in, but so you're saying April, May, June, 3 months?
That's what you had stated, right? Go ahead.
Yeah,
the middle of June 15th, that's 3 months.
Yeah, that's 3. Okay, sorry. Well, could I get 4 plus? The steps is made out of concrete. What's wrong with the steps? Because I don't know.
It looks like the railing. Okay, it may have an issue with the railing.
The railing I put up there is a wood railing because it's concrete steps. So we got a wood railing coming down and it's in the ground with concrete. It's sturdy. That's how we done it because we didn't put, we couldn't put it on the concrete. So
But
I could
Mr.
take
Chairman,
pictures and send it to you guys.
We have pictures, Mr. Chairman. Is this the railing? So we have pictures of the railing. Mr. Chairman, to the appellate, it's a non-compliant railing.
What kind of railing should it be? If
it should be, it's a railing that satisfies the residential building code, but it includes a graspable top rail and spindles no more than 4 inches apart.
Okay, I don't know what you're asking for. I try to find out the information to do it. Far as
Mr. Chairman, if you look, if you can, and you can't really zoom in, there's also if you're looking at the house, the column to the far left is actually displaced and collapsing. So
Yeah,
I don't know
it appears that down below there may be a gap there. So that's something you're going to have a look at structurally to make sure that you don't have a problem there, a failure.
If you look at Mr. Ruins, if you go to the other photo zoomed at this level, you'll be able to see that it looks like it's leaning on a plumb 2 to 3 inches.
Far as the column, I had somebody come out and check that. They said it's secure. It's not going anywhere. Over on that street that we guys live on, there's no sewer over there. We have septic tanks, and there's always water in our yards. So that's just from the house settling more, that I was told from a contractor. But we don't have no sewer systems over there, and we get a lot of water.
Mr. Chairman, I'm going to restate that the violations have to be abated. There is Mr. Chairman, have you contacted your inspector? Inspector Greg, to go over these items?
I tried to. I couldn't get anyone on the phone. Then when I got a lady the way she directed me to put in the application to talk to me, I couldn't get anyone on. So all I could do.
Well, maybe Mr. Vanover can get you in touch with that.
Yeah, because I tried to call, couldn't get.
Yeah, there's a few items that have to be taken care of. A little bit of the siding there, and also that the piece going underneath can't be open like that either. So you're going to have to take care of these violations and work with the inspector to be able to do it. So we're going to give you the time to get with this. What we're going to do is we're going to give you the April 5th to get the permits that you need, and June 15th to abate the violations.
Mr. Chairman?
Go ahead.
April 5th to register the property as a rental.
I'm sorry. It was April 5th to register the property. So you have to go ahead and get that, and June 15th to abate the violations.
Okay,
and Mr. Chairman, we continue to communicate with the inspector. Go ahead with your question.
You're breaking up, Mr. Garrett. Mr. Garrett, you're breaking up. We're not getting what you're saying. Mr. Garrett, for some reason you're not coming through. We're not hearing you.
Hello?
I don't know what, Mr. Rulins, do you know what might be causing that?
No, it just sounds like a bad connection.
Okay. I think he did say he was.
There we go. Now we can hear you.
Okay.
Yes, we can hear you.
Oh, you're cutting out again.
Well, now.
Go ahead.
Good.
We can hear you now.
We got. Okay, we're having a difficult time.
Just gonna stop driving. I don't have a problem with doing the violations. The house is gonna be back right now. This is. Hello?
Okay, well, we're still, you're still driving because we're not catching what you're saying. Okay, you're back again. Yes, we hear you. Yeah, it's not working. It's not working. You're not coming through.
What I'm saying is the house is going to get my company's name, but I will still. Jesus. Hello? Hello?
Okay, the hello I'm getting, that's about it.
Hello?
I'm hearing you with
Can
the
you hear me
hello,
now?
but that's about all that's coming through.
You don't hear me now?
Yes, we can hear you, but we can hear you, but you've got to stop moving.
Okay, I'm
Please
not moving
ask your
anymore.
question.
I'm standing totally still.
Okay.
I will take care of the violations. The roof, I jump on that. I jump on everything that you guys was talking about. If I have to, I'll get some kind of documentation because okay.
So, Mr. Chairman, the process
in the
is
front for our sport. The other
Right.
stuff, I take care of that. I can touch with the inspector. If you guys, I don't know the number. I could try to find the violation, but be told that I'm just saying I do everything you guys is asking me to do. I don't know how.
Okay. Mr. Garrett? All right, Mr. Garrett, here's what
Hello?
we're gonna do.
Yes, sir.
You need to get it registered, so that's an April 5th date. And then the June 15th date to complete the violations, I want you to work, with the inspector. And as long as you're making progress on it, you can continue on, as long as you're working on it. You understand?
Okay, I understand.
Okay. All right.
Mr. Chairman, Miss Aston had her hand raised.
Okay, Miss Aston.
Just very briefly, thank you, Mr. Chairman. You need to make that as a motion. You technically didn't make that as a motion. And he provided an email address. And if you notice on the bottom of his violation notices that were served to him, the building department provides an email address. He can go ahead and email the inspector to do that. And he keeps saying that he'll do what we want. The law requires him to fix this to code, and that's what the law requires. Thank you, Mr. Chairman.
Sure, sounds good. Okay, so motion for April 5th to register the property and June 15th to abate the violations.
Year 2021.
2021. Okay.
Mr. Mackey,
So moved.
Mr. Bradley,
Second motion.
Okay.
Mr. Mackey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes. Okay, you will be notified.
Thank you. You guys have a blessed day.
You too. Thank you.
All right. Bye-bye.
Okay, next docket. A100. Oh, we have one that's withdrawn. I guess A99-20 is withdrawn. Everyone's okay with that? No problem? Okay, docket A100 209708 Cardwell Avenue.
Application and fees are in order. Notice of violation is interior and exterior maintenance. Issued November 5th, 2020. Appeal statement received November 25th, 2020, requesting for time to abate the violation. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton, Law. With the appellate, please state your name for the record.
Raji Goldman.
Okay, solemnly swear to tell the truth, the whole truth, so help you God?
Yes, sir.
Okay. All right, go ahead and let us know what your plans are.
I was a little bit confused in regards to all this. I was already doing work on the house this morning, and then the inspector came, and of course, by it not being trash day, I had garbage in the backyard. But I was wondering if anyone could clarify one of the ordinances that I violated.
Okay, we'll ask Mr. Vanover.
Okay, in regards to ordinance 371.03, I thought it was in regards to a 3-dwelling unit that the doors had to be fire safety rated. And this unit is a 2-dwelling unit.
Yeah, that's what we're showing in the violation. We're showing it's a 2-dwelling unit.
Okay, and I'm just asking about clarification into the ordinance, 37103.
Okay.
It appears that it stated the fire rated doors were necessary for a 3-dwelling unit as opposed to a 2-dwelling unit.
Mr. Chairman, the city's going to object. It was not listed in his appeal statement for this objection to the notice. If he's asking clarification, the code reads what it reads. And if you notice in number 2 on his violation notice, the comments list the statement by the inspector. I'm going to object for the record regarding this. The codified ordinance 37103 says what it says. So the clarification in the comments as to how the application of it to this property are specifically stated by the inspector.
Okay. Then let's go ahead and hear from Mr. Vanover.
You're muted, Mr. Vanover.
Based on, Mr. Chairman, based on, all the comments made by Ms. Aston, I guess my question is there a request for more time, or is there a disagreement, an objection to the notice of violation is issued? This is a rental property. This was inspected under our, the inspector was from our rental inspection unit. So I guess that what is the plan for the appellate?
The appellate is, I'm sorry, I didn't mean to interrupt.
No, go ahead.
No, go ahead, sir.
Well, I've had the unit for a few years now. The tenant is on Section 8. So I've had annual Section 8 inspections up until this point, and I was just wondering, will we continue to be getting 2 inspections every year, or don't get me wrong, I'm just trying to get clarification and information while I have you guys on the phone. I am planning to fix all the violations, which I do every year, like I said, based on the Section 8 inspections.
So, Mr. Chairman, to the appellate, just for a point of clarification, all of the requirements for rental property are in the City of Cleveland codified ordinances. However, Section 8 does their inspection to HUD guidelines for funding, which is outside of our purview. Their standards are different than the laws that have been adopted by the City of Cleveland for residential dwelling standards. They have a specific list of things that they require for you to maintain funding. Entirely different authority. The City of Cleveland has a list of residential dwelling standards in our building code that have to be complied with, that are more stringent than HUD's requirements for Section 8. There's also, the City of Cleveland has requirements for HUD-safe certificates, as well as other codified ordinances regarding property. I can't opine on whether you will continue to get 2 inspections a year, but as a rental property, there will be, we have the right and the authority to inspect along our timeline. So I'm a little, I guess I'm not clear. If the ask is for more time, how much time?
And to answer your question, yes, it is possible that you end up with 2 inspections a year.
Okay.
One from HUD, one from the city of Cleveland, or other entities that you choose to involve yourself with. So the city of Cleveland has regulatory authority to inspect rental property. And HUD as a Section 8 landlord, in order to receive funds from Section 8 through your tenant, you have to meet their requirements as well.
Okay.
But I haven't heard how much time we're talking about.
I'm not sure. Like I said, I'm in the process of making repairs that are significantly more, I guess, to make the place more safer as opposed to the doors. And I was wondering, I heard what the young lady said, but I didn't really understand it in regards to 37103. Like I said, I am making the repairs, but if it's not required for me to replace an entire door because of the ordinance stating that the requirement is for a 3-dwelling unit, if that wasn't printed on my violations thing, it's not, I guess it's not the accurate representation of the ordinance, is what I'm trying to ask. So meaning my paperwork mentioned nothing about the fire ordinance be required for a 3-dwelling unit. However, when I look up the ordinance, that's what it tells me. And I was wondering if you guys could tell me where exactly could we find the listing of the ordinances, because I went to the building and housing website, clicked on ordinances, and it doesn't really take me anywhere.
So, Mr. Chairman, to the appellate, all of the ordinances are published through the Cleveland City Council website. They have a link to take that will take you to the ordinances.
Okay, so the link is on the Cleveland City Council website as opposed to the Department of Building and Houses' website?
Correct, because the Cleveland City Council is the body that creates the ordinances. They write the laws. The legislative branch of government are responsible for, and not to get into a civics lesson, Mr. Chairman, but the Cleveland City Council writes the ordinances. Therefore, they are the keeper of the ordinances.
Okay, it just seems like there would be, like I said, when I went to the Department of Building and Houses website, they had a link for the ordinances, but it didn't work. So I didn't know that the ordinances are listed under Cleveland City Council or their website.
Mr. Chairman, I will restate, this is an investment property, and it is a business operation because it is a rental property. As a property owner, both as a private property owner as well as a business, it is the appellate's responsibility to know which ordinances are required to be followed.
Correct.
That is
That's why. Correct. I'm sorry. That's why I tried to look them up, sir. I was just trying to get clarification. And
and now I've explained where the ordinances are, Mr. Chairman.
Okay, so Mr. Coleman, I would say that you need to get with the inspector and, if you need, to ask a question about something specific, but how much time do you need to complete these interior, exterior maintenances that you have going on right now?
Like I said, I'm unsure. I was unsure when I spoke with the inspector on Thursday because there are things that require immediate attention. I can get to those, but I don't have. I have to see how much money, because I have to get the roof finished. And I guess I can see where I'm at after that. But like I said, I had more pertinent repairs going on before the inspection happened that I had already committed myself to. So that's why I need time. I don't know exactly how much time because funds are low. I have no tenants in the house. I'm just working to get it fixed.
Okay,
I
so
guess whatever time
is
you
there,
guys.
we're looking at permits here, Mr. Vanover?
Bear with me one second.
Sure.
I'm pulling up the notice as well as the code section that's being discussed. So it appears that there are broken doors and water damaged bathroom ceiling. There's water damage to the floor. The furnace needs to be maintained. There's cracks and broken flooring in the dining room, and so, Mr. Chairman, there would be permits required for the replacement of the doors, but the balance of the work there is not.
Okay,
There's no permits required.
okay.
Good morning. I'm okay. How about you? Good.
All right, so if we're talking about 30 days to acquire all the permits. And 90 days to complete and abate whatever these violations are.
If you could give specific dates, Mr. Chairman, thank you.
Well, yes. Okay, so April 15th on the permits and July 1st to abate all the violations, 2021. So moved.
Second.
Is moved and seconded. Call the roll.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes. Okay, thank you, Mr. Coleman. You will be notified. All right, we're gonna call the next docket A 101-20, 3432 West 94th Street.
Application and fees are in order. Notice of violation is interior and exterior maintenance. Issued September 2nd, 2020. Appeal statement received October 2nd, 2020, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton Law. With the appellate, please state your name for the record.
Mr. Chairman, this is Patricia McGinty Aston for the City of Cleveland Law Department. As the other one, I'll do my tidbit here. But I do see a call in user 7, and I don't know if that is who the appellant is. But Mr. Chairman, the appellant having been asked to state their name by Ms. Davis and not having done so, the city will presume the appellant is not present to proceed, and I will ask Ms. Davis, was the notice of today's public WebEx hearing returned to the board's file for any reason?
No.
And Ms. Davis, did you receive any communication or notification from this appellant via email, phone call, voicemail, etc.?
No.
So, Mr. Chairman, the appellant not having been presented at this hearing right now for this being called to testify, the board does have proper notice to proceed in this matter under due process, and you can do so. I also requested or notified Ms. Davis the city was going to inquire as to whether or not the appellant who filed this with the board at last November 2020 provided to the board proper agent authorization to proceed. Did you receive that, Ms. Davis, from this appellant with the packet?
Give me 1 second. No, I did not.
Okay, so the city is going to object to proceeding under this. Well, you can hear from Mr. Vanover. We are going to ask that you uphold, deny, and remand. But the problem also is there's currently no registered agent with the Ohio Secretary of State as required by state and local law, which was what made me think there was a problem with this. So I will defer to Mr. Vanover, but if you are going to be inclined to give any time regarding this matter, we would ask, as this board is required to do, to have proper agency letters authorizing proceeding by the actual owner. Thank you, Mr. Chairman.
Mr.
Okay.
Chairman, I think call-in user is Mr. Vanover. Call-in user 7 is Mr. Vanover, so I don't believe we have any other call-in users.
Okay, I wasn't
right.
sure because he showed up. Okay, thank you.
Yeah, Mr. Vanover, and we are inclined to do that, to uphold looking at the pictures and to remand this back to you for any further.
Can you technically swear him in and hear from him so that it's
I will.
a proper hearing?
Okay. Yeah, very good. Okay, so solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay.
So, yeah, Mr. Chairman, the photos speak for themselves. The notice was issued. The notice was, properly issued. And the condition of this property, along with the administrative defects that Ms. Aston has already spoken to, just reiterates the pattern of neglect for this property owner. So they don't, they're not taking care of their administrative portions. They're not taking care of the building. We would ask that you deny any more time and remand it back to the Department of Building and Housing.
Okay, so we're going to do that. We're going to find that the violations are definitely do exist, and we're denying any more time, and we're remanding it back to the city. Motion?
So moved.
Second.
Motion by Mr. Maskey, second by Mr. Bradley.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes. Okay, moving right along. All right, so we got docket 102-20, 3370 West 90th Street.
Application and fees are in order. Notice of violation is no permit issued November 3rd, 2020. Present for the hearing. I'm sorry. Appeal statement received November 17th, 2020. Requesting for time to complete the abatement. Present for the hearing, Tom Hanover, Building and Housing. Patricia Baston Law. Would the appellant please state their name for the record?
Brian Norris.
Okay, so we have only one giving testimony. All right, Mr. Norris, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
I do.
Okay. All right, go ahead and tell us what your plans are.
So I applied for a permit on February 25th. I've called a few times and checked in online. It looks like it's still pending. So I'm not sure what to do besides wait for it to be approved.
Okay. Mr. Vanover?
So, Mr. Chairman, to Ms. Davis, when was the notice of violation issued?
One second. I want to say my note says issued on November 3rd, 2020.
So, Mr. Chairman, I mean, at this point, we would ask, it was 3 months after the notice of violation to make application. So that was February 20th. So we're right around 3 weeks in processing the permit. And it's, which would abate the violation notice for no permit. We would ask that you deny more time and remand it back to the department while that gets processed. I don't understand why it wasn't applied for in November. Or actually, I don't understand why it wasn't applied for before the work started, which is what the law requires.
Well, let's hear from the appellant. Go ahead.
Mr. Chairman, the appellant, though, is this owner occupied?
No, this is, there's a tenant that lives there.
Okay, so again, Mr. Chairman, this is an investment property. And
Yes.
as a business, there's an expectation that the, the parties that own the building have responsibilities to follow the law.
Sure, I agree. And this was a mistake in the original permit. I originally filed for the permit in my own name. That was incorrect. I need to have a registered contractor file for the permit because it is in an LLC and not my own name. So when I received notice of that in November, I reached out to the city to ask for a little bit more time, only because I think I was only given like a couple weeks and I was having a hard time finding a contractor to apply for the permit in the middle of the winter for some air conditioning work.
Okay. So you did do some work without the permit, is that correct?
That is correct.
Okay. So if we remand this, this will allow you to continue on. You're going to get your permits and get done what you have to get done. And as long as you're proceeding, everything's okay.
Okay, great.
Okay, so motion to deny any more time and to remand the property back to the city, for any further action to be taken. So moved.
Second.
Okay, we get moved and seconded. Call the roll.
Mr. Maskey,
Yes.
Mr. Maskey, Mr. Bradley,
Bradley? Yes.
Mr. Gallagher.
Yes. Okay, you'll be notified of that action, Mr. Norris. Thank you.
Thank you.
Okay, so we have time extension for docket 8/26/20, 10108 Flora Avenue.
Application and fees are in order. Notice of violation is a condemnation of the main structure issued November 13, 2017. Appeal statement received August 12, 2019, requesting for more time. Present for the hearing, Tom Vanover, Building and Housing. Patricia Ashton, Law. If the appellant is present, please state your name for the record.
Mr. Chairman, this is Patricia McGinty Aston for the City of Cleveland Law Department. I'm not showing any participant panel that is anyone other than the last appellant. I'll do my spiel here in case they pop in. Mr. Chairman, to Ms. Davis, was the notice of today's public WebEx hearing returned to the board's file for any reason?
No.
And Mr. Chairman, to Ms. Davis, did you receive any communications from this appellant regarding this extension of time via email, telephone call, letter, etc.?
No.
So, Mr. Chairman, the city's position is that you have the right to proceed in this matter, having given proper due notice to proceed for due process notice. I think we're going to object that you grant more time given these dates. I think I remember this hearing right before, but anyway, so we're going to defer to Mr. Vanover if you can swear him in, but I think we're going to ask that you deny any further time and remand. Thank you.
Solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead, Mr. Vanover.
So, Mr. Chairman, as I understand it, this is a 2017 condemnation from November, so we're looking at 3.5 years. This appeal was for a new owner who purchased the property in its condition, in its condemned state. They filed an appeal for more time. The board granted them more time, and they still failed to abate the nuisance. As I've stated in the past, the property was condemned. It was purchased condemned, and the a condemned property, that definitely influences the purchase price. This is obviously an investment to buy it, rehab it, and profit from it. So we would ask that you deny any more time. Those are assumptions that I'm making based on the record. We would ask that you deny more time, remand it back to the Department of Building and Housing.
Sounds good to me. So we will deny. We know what this was about, so even upholding it, we know it's a condemnation and nothing's been done with it. And we're going to remand it back to the city for any further things to be done to it. Okay, do I have a motion?
So move.
Mr. Bradley?
Second.
Mr. Maskey, second. Please call the roll.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes. Okay, we'll move on to approval of we have one resolution.
This is Patty, real quick, Mr. Gallagher. Did I miss, Carmela, did you continue or was withdrawn A9720? I got the other withdrawal. But did I miss A9720, 1441 West 25th from the building code sections?
Yeah, that was withdrawn.
Thank you.
Okay, very good. We have one resolution, A221. Motion to approve.
So move.
Motion by Mr. Bradley.
Second.
Is that second by Mr. Maskey? Okay.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes. Yeah, we got approval of the minutes for March 3rd, 2021. Are there any additions or corrections?
No.
Okay, motion to approve.
So moved.
Thank you.
Okay, motion by Mr. Maskey, second by Mr. Bradley. Call the roll.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes. So if there's no further business, this meeting is adjourned.
Thank you.
All right.
Everybody take care. Stay safe.
Tom, Mr. Vanover? Mr. Vanover?
Yep.
This is Howard Bradley.
I think he left.
What day
Looks
will
like-
you be in the office that I could see you?